Much time, I'd like to introduce former FBI Director and Chief Judge, U.S. District Court for the Western District of Texas, Mr. William Sessions, and Mr. Douglas Spaulding from Reed Smith, and they are going to talk about after releasing a report on this Guantanamo Bay, and they are going to talk about the report and their experience, and after they have spoken, we will have a Q&A session. Please state your name and organization you are representing, and I will hand over the mic to the judge.
Thank you. I only have a half hour, I understand. That's humor. These are difficult times, and these are dangerous times. These are times of uncertainty. They're times of war. I mean, all these things we know and we accept, and suddenly we have thrust upon us another problem, and that is that we were in battle against a unidentifiable, except by title, enemy. Uncertain about where they came from, where they were, how you dealt with them, what rights they had, what law applied to them, what conventions applied to them, if any. In other words, these are very difficult, uncertain times. And to me, it's a particularly appropriate time because we're 2 years past Boumediene. The courts have been struggling with it and making what I think is very good headway, very sound headway, dealing with every single problem that confronted them in trying to determine how those people who had been brought in one way or another and placed in Guantanamo, and whether and how they were entitled to be released. And when that happened, I was surprised. Now, I'm not a habeas corpus judge who spent his life dealing with habeas corpus. I've dealt with criminal matters all my judge life. I've dealt with criminal matters before. I've dealt with bond matters, bail matters, all those things that relate to freedom. I've sentenced a lot of people. But I knew instinctively that habeas corpus is and always has been one of the most important legal and appropriate theories because it relates directly to liberty and to men and women who are, they believe, improperly held. Sometimes we can't identify them because they don't have lawyers. And we're always thinking about lawyers who advocate for people who believe they are held improperly. And we may think it's not serious business, but to those people who are held, it's very serious business. And being denied of liberty is difficult to understand. So, when the problem came about how we would deal with this, you're familiar with the general underworkings, and probably specifically, you have the report that we've made today from the Constitution Project and from the Human Rights First Project. And these reports are, I think, frankly, very well written and very well outlined because they deal with the major issues that confront us. But the role of the courts has, from the beginning, been uncertain until Boumediene came along and gave us a degree of certainty and thrust back upon the courts the responsibility to deal with it. Now it's your problem. Take and find us the way. Deal with all these various, myriad, multiple problems that are so entangling. From the beginning, I will tell you, I felt that that was the absolutely correct thing to do. So I may be biased on it, not just because I was formerly a judge a million years ago, but because of the fact that it is clearly a job that courts have dealt with from the beginning. Somebody talks about the Magna Carta. We talk about the rights to habeas corpus, the right to be free, the right to express yourself in this country is very important. But how do you bring them into a proper jurisdiction? And how do you deal with them once they've gotten there? But this is the work of judges. This is the work of judges with juries as fact finders and judges of the law, or a judge acting as judge and jury. We didn't have the Congress of the United States telling us how we would do it. We did it, and we always submitted our work. It went upstairs. The courts of appeals told us when we were wrong, sometimes. And if they didn't, the Supreme Court undertook that task and did it admirably. But it thrust it back in our laps now, and that's where we are. I'm very proud of what the Human Rights First and the Constitution Project have done, because when you read the report, you'll find that it's in step with Boumediene, and it actually deals with every single problem that confronted the courts and the lawyers from the beginning. I'm sitting here with a lawyer who represents and knows, represents these people and knows of the frustrations of trying to find ways to get information, how to find ways to deal with what their clients endured, and confident that we would have a way out of it. Now, if I were to tell you what I think is most important about what you do and what we do, and you're witness to it, and you're evidence of it, you are the evidence of transparency. You are the evidence of open courts, of open procedures, of open discussions. And the whole world is aware that this is a very awkward circumstance, and they're waiting to see, I think, what we really will do, and we now have some good evidence of it. And it almost points like a neon arrow where we're going. We're going to continue to be open. We're going to continue to have lawyers representing people. We're going to continue to deal with problems and procedures and techniques and laws as they are and laws as they may be. I personally hope that the Congress will let us in the courts. When I say us, that's arrogant. I am not an us anymore, and haven't been for a long time. But we'll let the courts deal with those things that are so important, that there be a fairness and a balance about what they do, that we hear from the lawyers, that we know these people are represented, and we know that we're not just hearing what one side wants us to hear. We hear from both sides. We have 50 some odd cases that are proof positive. There's a place right up here in the front row. There it is. We've saved it for you. They are proof positive that what I am saying and suggesting to you is correct. And that is, the courts are equipped to do this, are equipped to handle it, are the right course where people can, even though the decisions are different, the government, I'm informed, prevailed in 40% of its defense, of its claim that they were entitled to hold. So that means 60 was the other way. That's not bad for 2 years of experience in connection with very, very difficult, if not intractable matters. I hope in a way that, maybe intractable isn't a good word, they are difficult of solution, and they will be, because every single case, that is, all the cases, are different, one from the other. And the experience of all the actors is different, one from the other. The only commonality we have is judges who have made decisions. Judge Hogan, who made his case management order, and that has been discussed, and it's in the report, and you can read what other courts did with it to perfect it. And who's to know if it's perfect yet? Because it may fit in some cases, and it may not solve them all. Anyway, that's my remark. I am not. I've read these cases. I've read the report. I worked the report. I helped edit I didn't write it. I helped edit the report. I think it's an exceptional piece of work.